Assalamualaikum warahmatullahi wabarakatuh. My name is NUR binti Saleh, and today I'm going to present a cyber law case review, which is a cases of SHERINNA NUR ELENA binti ABDULLAH against Will EDAR SDN. The citation of this case is 2014 MLJ 298, which is held in a court of High Court of Kota Kinabalu, and the judges was Stephen Chang JC. So the issue of this case is whether the plaintiff had the locus standi to bring and maintain this action where she claimed to be the owner of the copyright. First of all is the fact of the case. So the fact of the case for these cases is the plaintiff was a queen beauty from 1992 to 1994 according to the circumstances of the case. However, she had converted into an Islam in 1995 and wore a headscarf as a part of religion practice. The plaintiff bought her picture in the packaging of the defendant products in 2008. Specifically, container of rice, exhibit and sold in a different retail shop, grocery store, supermarket, hypermarket, and an advertisement board in Kota Kinabalu. Thus, the plaintiff argued that she possesses private right and that she was the legal owner of the copyright and her own photos and photograph, and that the defendant had violated her privacy right and infringed on her copyright. The plaintiff further claimed that the defendant flagrant disrespect of her private right had severely harmed her credit, character and reputation, and she sought an injunction Rm 1 million in damages caused by the infringement and exemplary or aggravate damages to be awarded. The defendant filed this motion according to 033(r)(2) of the Rules of the High Court of 1980 to assess whether the plaintiff has locus standi to commence and continue this action. Move to the judgment. The court held that the plaintiff claim is dismissed with cause and the defendant application, which pursuant to 033(r)(2) of the Rules of High Court 1980 is allowed. The plaintiff did not take or create the photograph or image that the defendant utilized on its merchandise. The plaintiff made no claim to have prepared, taken, or created the photograph or image. If the plaintiff owned the copyright in the photograph or images just by being in it, then the other two ladies in the photograph would also possess the copyright in the photograph or image. They were not, however, the parties to this matter, and the plaintiff had not demonstrated that they had transferred their right to her or agreed to her bring this complaint against the defendant for infringement of the copyright allegedly shared by them and the plaintiff. The Sabah Tourism Board owned the right to the photograph or image to obtain permission from the author or owner to use it on the book. That basically precludes the plaintiff from being the owner of the copyright and from suing for violation of the copyright. The photographer or creator of the photograph or image had not been recognized by either the plaintiff or defendant. The plaintiff failed to produce any agreement, document, or statement demonstrating that she had been assigned or licensed that was the owner of the copyright in the photographer or image, entitling her to sue the defendant for copyright infringement. Infringement of copyright are liable at the suit of the owner of the copyright, according to Section 37, Clause 1 of the Copyright Act 1987, because the plaintiff had not demonstrated that she was the owner of the copyright in the photograph or images used by the defendant. She could not sue and had no locus standi to sue the defendant for copyright infringement. Although the plaintiff was free to sue the defendant for breach of privacy, the defendant did not enter into private property and take images for the plaintiff without her permission. The photo was shot many years ago by someone else during beauty pageants in which she actively participated as a participant in the public. It was not a private event on a private premises. The photos were also not obscene. the plaintiff did not protest at the time that the photograph or image had embraced, mocked, or scandalized her. So we move to the critical opinion. Finally, based on what I have learned and witnessed, I believe that in this case should serve a wake-up to all Malaysian celebrities, models, politicians, and other prominent personalities who are always in a public glare. We should know that has no image right legislation. As a result, whether they are public photo shoot or event of a person, the photographs are normally owned by the photographers. As a result, Malaysians cannot claim ownership of the photo and their multiple duplicates. In a nutshell, if there is an occasion such as modeling, birthday parties, wedding, and so on, those who participate in the event should ensure that the ownership and the copyright of the image is taken limited to use in other publication and product associated with the occasion exclusively. If the photographer requests that the photograph be used for the other goods and publication, the regulation can be established mutually. Normally, Ford would change the photograph extra expenses, but it is entirely up to the parties how they want it done. For example, if I were the plaintiff house, I would want an agreement to remove all the images before I convert into Islam in order to respect the position and religion I'm currently in. Overall, use caution when it comes to your own rights.